Thank you. I just want to comment. It's like Ukraine has brought most Democrats and Republicans together. Qualified immunity has meant the Democrats have called a Cato Institute person as our witness, and the Republicans called a union official as theirs. Mr. Nadler, you're recognized.
Thank you, Mr. Chairman. Let me start by setting the record straight. Mr. Johnson said that I suggested decreasing the funding of the New York City Police Department. It is true. There was a movement at that time to shift some of the functions of the police department to another city department. I agreed with that, and as the function went from one department to the other, so should the funding associated with that function, but the total funding was not suggested to be decreased. Mr. Schweikert, do you agree that qualified immunity has failed as a matter of law, doctrine, and public policy? And if so, why?
I do agree with that. I think it's failed as a matter of law for reasons that Professor Reinert has already ably explained. It was simply an invention of the Supreme Court. While there is some dispute about whether the early Supreme Court cases employing an actual good faith understanding of qualified immunity had some support in common law, there is no dispute at all amongst any scholars today that the current clearly established law standard is absolutely unsupported by either the text of Section 1983 or the history on which it was passed. And it's failed as a matter of, as a practical and moral matter, because it has denied justice to victims whose rights have been violated, and it has undermined the efficacy of the law enforcement community by exacerbating the public's unfortunately accurate perception that police officers who routinely commit misconduct are not held accountable.
Thank you. Professor Wright, first off, congratulations on your victory in the Supreme Court litigating Taylor versus Rojas. It's an incredible accomplishment, and we commend you for your work litigating on behalf of Mr. Taylor. It seems the Supreme Court almost always decides its qualified immunity cases through this shadow docket. Can you describe why this practice is problematic?
Thank you for your question, Chairman. The practice of deciding cases on the shadow docket is problematic for a number of reasons. First, it puts the processes of the Supreme Court behind a curtain that shields it from public view. And so when a case is decided on the shadow docket, there is no public argument. There are not even briefs on the merits. And so it prevents the public from understanding what's happening, and it allows the Supreme Court to make law and even some policy decisions that govern parts of the United States without any transparency into the process. And so that's problem number one. Problem number two is when you decide these cases specifically on the shadow docket, qualified immunity cases, these are often cases where the facts are in some dispute. And when you do it on the cert stage briefs alone, there is no opportunity for the parties to air that disagreement or to put the actual questions and the actual facts before the court. And so it impedes lawmaking and impedes public trust in the judiciary processes.
Thank you. Captain Thomas, how does qualified immunity exacerbate our accountability crisis among law enforcement?
Accountability piece, that's what we're trying to do now. I'm saying, because we got to make people believe that the police are here to do the right thing at all times. The qualified immunity piece, we had officers now, when this came up in Louisiana, they're actually buying umbrella policies just to protect their families. So taking this qualified immunity out of this talk, we've been in a situation that we can't control. We couldn't control it. So we all need to just get together. That's why we're here with Congress. That's why I'm glad we have our colleagues here so we can discuss this thing, because we need more talking on them points.
Thank you. Judge Newman, can you explain how qualified immunity undermines official accountability and precludes individuals from effectively vindicating their constitutional rights?
Well, I don't want to see the matter overstated. I think it does that in some cases and in some cases not. I've heard the statistics today that very few cases are dismissed on qualified immunity, but in the 30 cases I presided over at trials of the district court, most of them resulted in a jury finding in favor of the police officer. And I think qualified immunity was simply they didn't understand it. We did a poll later of all the jurors who heard these cases. It was clear they didn't understand the doctrine at all. And my sense was they were simply finding for the police officer because they didn't want him to have to pay, and they were unaware that the city was going to pay. So it undermined it in the sense that it tilted the scales in favor of a verdict for the police officer in a case.
Thank you. Professor Reinert, proponents of qualified immunity often argue that the doctrine is necessary to protect officers from being subjected to second guessing of their split-second decisions. Can you explain why this viewpoint is incorrect?
Yeah, it goes to something that Mr. Schweikert laid out in great detail in his testimony. The basic reason it's unnecessary to protect officers from being second-guessed is because the substantive law already does that. That is, I can't violate the Fourth Amendment as an officer unless I act unreasonably in light of all the facts that I know, in light of the circumstances, taking into account split-second decisions I have to make. So already I'm protected by the substantive Fourth Amendment doctrine. It's therefore unnecessary to have an extra layer of protection that qualified immunity provides. What that does is it actually, in a way, protects officers who come up with novel ways of violating people's constitutional rights, and then they're protected because no prior case had said that this particular way of violating someone's rights was unconstitutional.
Thank you. My time has expired. I yield back.